Okay, so we're starting a little late, so I'm going to get started. I'm Dune. I wanted to introduce our panelists. Next to me, we have Bob Parisi, who is a managing director at Marsh, and he's in charge of their national cyber risk product. Next to him is Sabine Schilg. She is a vice president for M&A, specifically dealing with integration for security companies into IBM. And then next to her is Sharon, who is a partner at Pepper Hamilton, and she's chair of their privacy and data protection practice. So I think we're going to start. They're each going to speak for a few minutes and introduce what they do, and then we'll go to questions, and then at the very end we'll have questions from the audience. So thanks very much. Yes. Oh, sorry. Sharon's going to go first, and then Sabine, and then Bob.
So this panel is a little different perspective than the first, dealing with the transactional side and the regulatory side and the impact on the deal structure. So I'm a corporate lawyer. I also get involved in privacy and security, global regulation, and there's a lot of activity right now because most of the deals that we're dealing with involve digitized assets. You know, beyond IP, it's all about data, who owns it. Is it secure from a privacy perspective? You have a database. Can the acquiring company use it? Can you transfer data across nation states? So there are a lot of transactional issues involving assets, and it doesn't necessarily have to be a technology company. It's really every single company that's doing consumer engagement today that needs to be in compliance with privacy and security. So that's what we do. We do data breach response as well, and then pass off to our litigators in the firm.
So I was asked to share a little bit our integration approach and how to acquire a company and what we look at if it comes to privacy and security. So we acquire quite a bit of companies, so approximately 100 over the last 10 years, from rather small startups to decent size existing organizations. And over the time, we have evolved here to integrate the whole thinking around security pretty comprehensively, and it's advancing lately a lot, given the fact that there's more and more software as a service or cloud businesses, which make it much more complicated to look at the end-to-end system. So if we talk about M&A, we talk about the fact typically of starting with the diligence phase, where we basically ambush an organization with 1,400 questions at the time when we acquire a company, from how do you do your business, what's your revenues, what's your contracts, what's your structure, what's your products, what's the intellectual property, and we added into that more and more when it comes to security. To get a first sense, we talked a lot in the first panel about IT security, but it's also about the people in the company and the ecosystem, end-to-end system, from vendor suppliers, temporary people that work. But also to look at it not only as IT security, but also from a business continuity plan and what that entails, because it also actually introduces more things to consider when it comes to data security and what to do with it. And then this is part of our diligence process where we gather data, and then we do, shortly after we decided to buy a company, a data risk assessment when it comes to security, where we bring in our experts, so that is our CIO team, not external vendors or others, to do a 4 to 5 weeks assessment of everything surrounding security. And that is predominantly the IT side. It includes certainly vendors such as Amazon, as mentioned, to look at what the company's done, what they done with their vendors, what kind of contractual dependencies are there, what was contractually actually committed to also their customers. Because that's, I think, something which I've encountered mostly as a challenge, that there is one thing what's done internally and having a good sense about it, but very often the team that looks at cybersecurity and privacy is not necessarily connected to what's being put into a contract to a customer or to a vendor, and what are the discrepancies. And then we take, based on our findings, action plans which often go more than, definitely more than 12 months, very often up to 24 months, until we feel totally confident that we've assessed and changed all that we think is necessary to look at these aspects. And looking at an M&A process, it's also quite different if a company now is part of an organization such as IBM, where all of a sudden the expectations are also much, much higher to us as a vendor, if you purchase software, hardware, or services from us, to then have contractual commitments to our clients. And furthermore, we take everything globally, so no matter if it is now a North American company and a North American standard, to now be prepared to transact with the nice new shiny objects that we have worldwide, brings in a totally new aspect that often smaller companies haven't looked at yet, because they very often focus on the US market first. So this end-to-end process has evolved a lot, and we've done a lot to look into that. But really, I think my main message here would be IT, and IT security is one element. But then think about breaches are now, for the majority, coming actually from the inside. So just looking at IT and IT security from a parameter perspective is not too helpful. So you have to be prepared to look at all these other elements to be ready for it.
All right, I was waiting for the green light. So I'm clearly the shallow end of this panel. So this is, at Marsh, we help clients understand their risk, quantify their risk, and then look at a financial way to transfer that risk. Companies typically manage their risk, all risk, across a spectrum, and they use policies, procedures, and technology. And at some point, you get to the point in that spectrum where an additional piece of technology, an additional policy procedure is not going to lessen that risk. It might actually make it worse. Talked about two-factor authentication today, or any authentication. You can make that password so painful that it becomes not a authentication factor, it becomes a sticky note on the back of the computer, in which case the policy is now being honored, but not necessarily actually helping to manage the risk. And so in the context of a mergers and acquisition, in the context of just helping the client understand that risk, we look at it in a couple of ways. We look at the policies and procedures, the protocols. We also look at them from the outside in. While policies and procedures will tell you what the company's aspirations are, finding out how the company manifests itself as it wanders around the world is helpful as we present them to the insurance carriers. One of the things I did want to talk about, because we talked about security a lot, what we look at when we talk to clients is not just about privacy, it's not just about security, it's more about the question of resilience. A company that's being bought, it's wonderful to know that they've got really deep moats and really high walls, but I don't know whether anyone threw this quote out yet, but there are two types of companies, those that have been breached and those that don't know they've been breached yet. We're in a situation where every company is under attack, every company is vulnerable. It's how you deal with that vulnerability, how you deal with that event and work through it. So when underwriters look at companies, when they look to allow you to offload some of that risk to make that transaction more meaningful, whether it's in a reps and warranty policy, whether it's in a cyber insurance policy, it's looking at how resilient those companies are to managing that risk. And security is part of it, but it's also general operational risk, the use of technology.
Great, thanks guys. So I wanted to start off by asking you guys to share the worst case you've ever seen just to get the worst case out of the way and talk about sort of what you learned from that and how that reflects some of the Achilles heels that you see in deals.
Well, just from a nightmare perspective, and I think the first panel hit this a little bit. There we go. Was the worst thing from a corporate perspective, excuse me, is a shareholder derivative lawsuit, right? And so Wyndham, the classic case that we had in terms of the multiple breaches, with over 600,000 records stolen. The shareholders were very disgruntled about that, and they started a shareholder derivative suit. The issues there were challenging the board by saying, hey, you really had sloppy security practices. Look what the FTC has done. We spent, gazillion $million on lawyers trying to defend these cases. You breached your duty of loyalty, and you breached your duty of due care, right? Your fiduciary duties. Ultimately, the business judgment rule prevailed, but that sort of, really personal action against a board is really, from a corporate perspective, the worst case from a security view. From a deal lawyer's perspective on privacy, something happened here in the bankruptcy courts in New York, which I think at least, should give us all pause, which is, you had the company Quirky. Quirky essentially, allowed young inventors to come up with, their own customized electronics that they wanted to do. But with the age of 3D printing, they're going into bankruptcy, right? And so they're selling the assets of the business. And part of the assets of the business was personal identifiable information of all these young inventors and creators. And the bankruptcy court had to deal with an objection by the trustee that said, you have no rights to sell this data. Where do you think how are you possibly going to get permission from 1.2 million users in the community to give the rights to sell PII as an asset of the business? We're going to appoint an ombudsman. We're stopping the deal because you did not put the right privacy policies in place and get consents from all of that 1.2 million folks to be able to do something with the data that was entrusted to you. So from a worst case scenario and from a proactive perspective, we really think we have to look as corporate lawyers for the long view, right? The whole life cycle of data and the life cycle of the business, which is cradle to grave. The startups trying to get in product design, privacy by design, security by design, going through collection, use, storage, transfer, and ultimate destruction of the product data, as well as the individual PII, and also the life cycle of the business, which ultimately, do you want to do an exit strategy, an event, or a dissolution? And make sure that you have your assets in place and you can do what you need to do to maximize value of the business.
Well, luckily, I don't have really bad war stories because we would be equally conscious about issues that we find actually in the diligence process and probably not pursue it if we found something majorly wrong. But the elements that I keep seeing is the fact that everybody has, prepares for M&A and has a view of what's important to us. So we get all these questions as you went through. What are your protections? What is your access control? What is this and that? And you get, you get always the answers, yes, we have it, and you look then at it. But then you look at access control. Yeah, you have access control, but everybody in the company, including the person that goes and runs out for lunch and comes in and out, has access. So yes, you have access control, but then everybody's on the list, and that's not really access control. Or the fact that the awareness of even what is PII and how is it differently treated depending on industries. Like you have a banking application and it even has a health standard like HIPAA exposure or things like that. These interdependencies are just not known. Smaller companies focus on their new business model, on their innovative idea, and what they provide, but usually don't have the broader sense of what are the legal exposures and privacy exposures in other directions. So that's just the common theme that I find everywhere.
So not everyone has the policies and protocols that IBM has. Luckily, as a broker, probably luckily when I was an underwriter, it would have caused me more concern. But we had a large company, a very large company, that bought a smaller, older company in their industry, and they did not do the same level of intrusive yet diligence. And it actually was left to us to notice that there was a newspaper article that this smaller company had just been raided by the Secret Service because they had found a significant amount of their, not raided, but the Secret Service knocked on their door to tell them that they had found all the information from everyone who had applied for a mortgage at this one company in a meth lab. They had found the shredded documents. They had found all of this. Now, the acquired company had known about this. 3 months later, after the acquisition, it became public, but it was not disclosed during the acquisition. So now my client, the acquiring company, was left with having to explain to its carrier, well, why didn't you tell us this? And there's something called a retroactive date in insurance policies, which means that there's no coverage for anything that occurred prior to that. There's also no coverage for things that you should have known but didn't because you just didn't do appropriate due diligence. So we were left with explaining why the incredibly expensive policy they had just bought is not going to cover exactly the facts were perfect. They were loss of private information. Well, we bought a privacy policy. Why is that not being covered? Well, it's not being covered because you didn't disclose it. It's not being covered because you then took actions which were to the detriment of the carrier, and that was probably the worst.
I'm going to switch ahead. I'm going to jump ahead to a question that I had planned for later, but because you mentioned it, I'm curious. Sort of maybe you could walk us through how a company, because cyber insurance is growing, and companies with all of these breaches are more and more interested in it. So when you're making an acquisition, how do you make sure that the policy that you have is going to cover both the transition period and the new entity, post-acquisition? Like, what do you have to disclose, for example, of your due diligence and that kind of thing?
Well, I don't acquire anybody. At least I haven't recently that I know of. What typically happens is a policy will have an organizational change provision. That's more about if you are suddenly bought, because the carriers underwrite to your level of controls. If you are bought, if you're sold, if you acquire another company, the acquiring company may have different controls. The company that you buy may not have that same level of control. So usually there's a grace period and a size period. So if you're acquiring a company that is 1/10 your assets, 1/10 your revenue, most insurance policies will allow for that just to come onto the policy. They're figuring that's so inconsequential, it's not going to cause a problem. Historically, that's not what happens. But if you are acquired, then your policy goes away. You are no longer you, technically. And as part of the due diligence, there's a couple of aspects in insurance. The first, as part of a merger and acquisition, is usually what's referred to as reps and warranties coverage, which is meant to provide coverage during the deal for any representation and warranties that the company that's about to be bought has made to the company that's about to buy it. The thought being, do you have the rights to the intellectual property? Are the key men going to stay? That sort of thing. That tends to get you through the transaction. But looking at if the company is large enough, and so my example of them buying a smaller company in the same industry, the carrier is going to ask, are you buying this company? You will want to tell your underwriters that this is going on so that you do have a smooth transition, so that you do have continuity. The worst thing you want to have is to bring a company on, have them have this loss, and have determined that, well, either they didn't fit within the 10% threshold, and or you didn't tell us about it, and or we don't like their controls, so it's now in our discretion to take it or not take it while you're going through a claim. So it's always about kind of almost going through the underwriting process over again as you acquire a company of sufficient size or magnitude.
Thanks. Sabine, IBM sounds like the gold standard, and I wanted you to talk a little bit more about the process, sort of just from a process standpoint. I mean, 4 to 5 weeks of due diligence before you make the decision, and then this extremely long kind of review once you've decided to do it. How do you keep track of all that data? And then secondly, you talked about sort of the things that there are all these people involved that you're not necessarily thinking about. You're thinking about the data, but how does that come into play if you're going to be thinking about the people involved? What do you want to be thinking about?
Okay, so what I mentioned was just the elements to cybersecurity. So we ask very generic questions, very open questions at the part of diligence, where we ask, what do you do to protect your people data? What do you consider as your crown jewels that you need to protect? And what kind of controls do you have in place? So it's a lot of description of process that we ask for before we acquire a company. Now, if you look at, usually it's smaller companies that we do acquire, and if you look at that, usually the company translates that to looking at its security from a perimeter perspective. How can I avoid that anybody gets into my network? How can I avoid that any data can be accessed? But very often that thinking is not very broadly advanced to look into the fact that it's not a lived awareness of IT security. It's really thought about, I built the boundaries, think about it like a house with all alarm companies outside. That's what companies usually do, versus looking at it to make security a theme in their company and really have an awareness and protection level, as well as really looking at it, what has to be protected in different ways. After we acquire a company, I often send in a team that is substantially larger than the whole IT organization of the company that we acquire to really make that assessment. And that is usually very hard for the company because it's viewed as big company comes with lots of process, but over time to look at, what are vulnerabilities, what are exposures, what is, the procedure to keep it current and updated, how fast to react, how to deal with vendors, how to have an end-to-end process. Is that what we commit to customers is lived by the organization? Is one time is an assessment, but then it also has to do with a lot of focus on education of the people and the team. And to do that not as, okay, just imagine as being reactive if something happens, but to start having a sense that security is part of making business and it's part of a day-to-day operation. That's usually a very hard switch because everybody is very proud of what they have built and that they are even being acquired. But it's a cultural shift to have to embrace that and think about that. The other element that I mentioned is to look at business continuity plans. It's usually something that, depending on the industry companies are in, is being thought of, but is very often translated to, I have a data backup. And a backup is not necessarily a continuity plan. Very often what we find is that the element of having a backup is good, is thought through. It's also kept in the right places and safely and encrypted and whatever. but it was never tested to go back live. And it was never considered that what is required, what skill is required to do something with this backup. And that business continuity also means that critical skills need to be more than one person, and if the one person has an accident, you're not able to go back live again. So business continuity as a holistic element to really test it. I tend to do that in the first few months after an acquisition, because that's a very good learning factor for the company, and it changes automatically the attitude depending on what you find. So doing testing of what it really means to go live. The third element from a people perspective is really look holistically at the background of people. Just following regular standards, so nothing extraordinary. I mean, we don't want to do more than what is legal and be passing, but to look at it and also to do that holistically, because it's quite normal, especially, I mean, I buy companies in the security area, so there is some sense of who is hired, and very often smaller companies do actually a fair amount of background check and whatever, but does it apply to all suppliers? Does it apply to all students? Does that, I mean, what else? I mean, what's the mindset and to do this, to really ensure that everybody has access to it, is being followed. And okay, so you wanted to go and have some offshore development. It also applies to your team in India or wherever you applied and are thinking about having an ecosystem. So background checks, I think, again, are a very common theme for employees, but not for the end-to-end ecosystem of everybody involved. So that's where we pay a lot of attention. And then it just has to be a culture shift, so that security is not a threat, but it's something that's being lived and really dealt with.
So that's the gold standard that you just heard about. Bob and Sharon, when you're advising companies that are small to mid-size that maybe don't have all of this expertise in-house and don't go through this that much, what are you focusing on?
And I think that Sabine is really engaged in a cultural or transformational shift to make sure that privacy by design is sort of enterprise-wide throughout the organization. The deal structures that we're engaged in, especially if they're dealing with smaller companies in the private equity space, are really, you know, we need to get consumer engagement. We need to get a smaller company as part of our infrastructure that can be new and innovative and, you know, get us into the digital age. In those kind of startups, you're right, they're not going to have the people or the process in place that really makes buyers comfortable today, right? So as lawyers, we'll put in all the bells and whistles and the reps and warranties, and they can get the reps and warranties insurance. But in doing due diligence, they might have a risk assessment. That risk assessment is very broad, to your point. When you then have to interview the founders of the business and ask them, did they build in privacy and security in the design of the product or service? You know, it's almost like an interview and no documentation. It's sort of, okay, can you tell me the story of how you started and what were your thought processes and what did you think you were going to be doing with the data and what consents do you have in your privacy policies in terms of use, and did you ever save any of those privacy policies in terms of use so that the individuals that are now in your database have appropriate consent? I didn't think of that. So you end up in a sort of oral history of how the company started, how the product started, and then as a deal lawyer, you're mentally calculating how much is that basket and cap, right? How much are you dealing with in the escrow? How much are you thinking about the indemnification? And do I get insurance to cover that risk? Because you're not going to have 100% comfort with the due diligence compliance. if they have documents at all, and if they, in fact, have a risk assessment that they have kicked the tires and been able to implement. What scares me, just from avoidance of litigation perspective, is when you have smaller companies who have done the risk assessment, have put it on the shelf for a couple, 3 years, and have done nothing to be able to address the gaps. And it is not a privileged document. So you have this piece of paper that told the founders, you know what, you're not in compliance with regulatory and legal actions. And guess what? You're now in a rep and warranty situation where every single deal is going to have compliance with applicable laws. Can you make that rep? Can you really? And at the end of the day, what happens if down the road, when those founders are now part of the new entity, there is a lurking security issue, or the data that was valued as part of the asset vaporizes? So those are the sort of issues that we're dealing with and trying to mitigate risk in doing as much diligence as we can, and also advising the acquiring company to say, okay, my assessment is you have a mobile medical device company that maybe gets HIPAA, has no idea about FTC regulations. So when you acquire this, budget $500,000 to go fix it in the next 12 to 24 months, and hire the right team and the right advisors and the right people to get in there so you can transform the data, which is not usable today, into something that is a real asset of the business. And just to tell you a real personal example, I was at a board meeting last week where we had a small company we were advising, took a round from private equity. Private equity was not happy with the founders and gave an exit plan to the CEO. And private equity was saying, you guys don't have scale, you don't have infrastructure for security. To do this from an enterprise-wide perspective, we want to reinvest $3 to $5 million. The good news, the bad news is it totally dilutes the founders. And so and that's what is happening and trending on the corporate side. Security is important. Small businesses haven't scaled. They're going to need a lot of money to get compliance up to speed. And private equity and the money talks, and they want that to happen. And ultimately what will happen is that the companies will either pay now or pay later in terms of their own equity investments.
Bob, did you want to?
Yeah, no, the ship is usually sailed by the time the insurance broker gets involved. The best we can hope for is that some of our clients do come to us and say, we are doing these things, we are doing these transactions. Help us understand what we should be requiring. What should inform our process when we look at how a company deals with security? So some of the companies will actually come to us and say, should we be using the NIST framework? Should we be using the ISO step? What should we be requiring that the companies show us as we go through? And how should we be looking at this from, for example, an aggregation standpoint? How does this change the systemic risk that we're bringing onto our balance sheet as the acquiring company? But that's rare. It's usually we've done this transaction. Now get it insured for us. But
Excuse me. I was told there was going to be a clock somewhere, but I don't see a clock. So what time is that? I just want to make sure we're.
You've got, I think, another 20 minutes.
Okay, great. Sharon suggested this question, and I think it's a good one. I hear a lot of talk about how boards are so much more involved in dealing with the cyber risk right now, and I wanted to understand if you find that to be true, and how they are more involved and how they're dealing with it, and how cyber risk is different from other types of risks from the board perspective.
Yeah, I absolutely see that. Boards are involved, and security is a board issue. But sometimes I think the thinking then, it's not that it's just this action plan on what to do with security. I mean, security is a board issue, digital is a board issue, being in the Internet of Things is a board issue. So it's this mix of activities and not seeing security as something just being prepared for a breach or something bad or to avoid that, but rather to balance that and really drive their organization into a security-aware team and culture. So I think for the boards, it's the same thing into looking at, to really make the assessment then, what are the crown jewels to protect, how to have a risk-balanced plan to deal with it, and to really find a way to engage the company in the security process, and not just looking at now something happens and we need to react and being reactive, but really proactively. I mean, how do you have a security awareness? How do you make it a topic? How are you prepared for it? And really having the teaching, the training, testing as a regular theme in the company to balance that against other opportunities such as digital selling, for example. So it's a board issue, but it's not just to be prepared for the breach. It's how to deal with security as another element, how the company really is successful.
We're definitely seeing cybersecurity and privacy being raised at the board, and I think general counsels are certainly aware of this as a risk. The disappointing thing is that I think the statistic is 70% of general counsels think that it's a risk, and 30% believe that their companies are in jeopardy because nothing is being done about it, right? So they're talking all the time. Yeah, you know, we got to do this. And the message from a legal perspective that we try to convey is this is not something you can just kick the can down the road, right? I mean, you know, audits are happening on the regulatory side. You know, you have to think of this as part of the life cycle of your business. It's not an IT issue. It's an enterprise risk business issue. And trying to transform that awareness in an age where, you know, money is tight. And unlike other corporate risk, it doesn't have a category on the P&L. It doesn't really look at the financial statements and you can see, oh, there's the breach risk, right? But what we are seeing is that audit committees are talking about it offline, and the IT folks are engaging in that exercise. So the CISOs are not having really a seat at the board table, but they're definitely involved as part of an interdisciplinary team and report up to the audit committee, and then the board gets that report. So they're getting reports. What really we need to see happen in order to make a difference and to avoid litigation and mitigate cyber risk is that action plans have to be taken, and they have to get serious in investing and being able to spend money when at the moment there really aren't dollar signs that they're covering. It's sort of, how do you prove a negative? How do you say you should invest money so that nothing happens? That's a hard conversation to have at a board level, but one that is necessary from an awareness and education and transformation perspective as you get into the digital age and the Internet of Things. So we're seeing a lot of discussion. We're not seeing a lot of concrete steps and actions that need to be taken to shore up privacy and security, except, and I will give this caveat, where private equity is involved, as I mentioned earlier, and or it's a highly regulated industry. So healthcare, for example, you mentioned on the HIPAA regs, you know, they have a ton of enforcement actions that are happening. And the executives know that they're going to be audited eventually. Those industries are taking actions on privacy and security.
So just quickly, you said you've met with the board. If you've seen boards, they look a lot like a meeting of my uncles and my dad. So by definition, they are a little hidebound. We've seen Oliver Wyman, which is one of our sister company of Marsh, did a couple of surveys. One found that 54% of the C-suite thought that their board was adequately able to engage or address or be involved in cybersecurity, security, information security discussions. That means they thought roughly half wasn't. 38% of the board felt they were adequately informed by the C-suite to be involved in discussing. That means that almost 60% wasn't. Transfer those numbers and imagine if we were having the same discussion with the board around gap and gas. Half the board doesn't understand where the company is with regards to compliance with financial reporting. Board's out, class action, class certification. I mean, it would be horrible. Two things that probably drove this to the board level. There was an article in the CIO magazine a couple of years ago, and they asked them what the most important regulation was. And anyone want to guess what they said? No? No one? Okay. Sarbanes-Oxley. You should have raised your hand, see? Sarbanes-Oxley, because it mandates that, they affirm that what we're telling you is true, which means that every system that reports or gathers information and pulls it up has to be secure and working appropriately. That's a scary thing. The other was in October of 2011, the SEC issued a guidance called CF Disclosure Topic 2, which said, we're not changing any rules, no new rules, but what we're telling you is that if you're a public registrant, if you've got public debt, if you're SEC regulated, you have to basically realize that we're going to treat cyber risk as a potentially material risk. So if you have a technology issue, if you have a breach issue, you have to put that through the same materiality calculus, and if at the end of the day you deem it to be material, you've got to start making disclosures. That landed like a thud on every director's desk. Those two things, in addition to lots of breaches, made this a very big board issue. And taking it personally, once the board calls the chief financial officer, who then calls the treasurer, which is usually where risk management resides, and asks, what are we doing about cyber risk? And you only call the treasurer to find out, when they say that, they mean, are we insured against this risk? That's huge. And across my client base, 10 years ago, those conversations weren't happening. In the wake of, and I'm not allowed to say client names, but in the wake of several large retail breaches, several large healthcare breaches, all of a sudden, 2014 was the age of our board just called. We have to have something in place. So they're calling us on December. We have to have something in place by February 1st when the board meeting is. If you also look at annual reports, we saw a 600% increase in the inclusion of a paragraph that just talks about we have technology risk. We have the way they do a lot of other boilerplate when there's not an actual risk they can point to. Look at most publicly traded companies. There is now a new paragraph that wasn't there 5 years ago that talks about their systemic vulnerability to technology and information security. That means the board, if it gets in the annual report, the board is thinking about it.
I just have a question to follow up on Bob's. So yes, I get they have that provision and that the boards are calling you for insurance, but what action items are they really taking other than, you know what, it's insured, I'm good? And the question goes back to what Sabine talked about, the process of transformation and making it privacy by design and security by design isn't like a call to the broker or the carrier as much as it is educating the people, the workforce, doing the deep dive on risk assessments, and having that 4 to 5 month risk assessment followed by the 12 to 24 months integration, right? And so I guess the fundamental question is, before the insurance is issued by the carriers, what sort of due diligence is done?
Well, thank God it's not 4 to 5 weeks in a year. Carriers have adopted, cyber insurance has no actuarial data behind it. Even if you accept that the risk goes back to when Al Gore invented the internet, that's still, what, 25 years? So when you look at insurance, they tend to think of actuarial data in terms of decades upon decades of information, huge amounts of data, workers' comp, auto. So what the insurance community has done is they've created a hurdle. You have to hit or be able to jump over a hurdle, and then you could theoretically qualify for insurance. They started with the BS 7799 standard. They've moved to the ISO 2700 standard. They now tend to look at a NIST-based approach, but because it's a bunch of financial lines or management liability underwriters by and large, it's at a corporate governance level. There's no way for them to be able to get as intrusive of doing pen testing, ethical hacking. They have to look at policies and procedures with the assumption that if you've evolved enough to have a policy in place around an issue, if you've developed to the point where you've got a CISO or a CIO and they report outside of technology into the board, it's unlikely that you wouldn't also be implementing appropriately, because you can't kind of walk out and breathe air and walk on the water without actually having aspects of that. Whether that assumption is correct or incorrect, they're doing that as, unless you meet these standards, we're not even going to talk to you about insurance.
So I think we're very short on time, and could we do one or two questions? And so just wait for the microphone to come to you and ask away. Anybody? Okay, if not, we will move on to our next panel, and the moderator for that panel is Don Applin, who's managing editor for privacy and data security news at Bloomberg BNA.